Hello everyone, Derek Johnson with Tatango.com. We are answering TCPA questions today, and I'm here with a TCPA attorney, John Nelson. The question we have today is what TCPA issues are pending at the FCC right now? So, what is the answer?
Well, that's a pretty big question.
Okay.
And I guess in order to get there, we need a little bit of backstory. So a while ago in March, we had the big DC Circuit case, ACA International.
And this is 2018.
2018,
Okay. Yep.
in which the DC Circuit essentially struck down several different portions of the TCPA and how the FCC was applying that.
Okay.
And since then, we've had a lot of activity both in the courts and also at the FCC on this issue. And in fact, some of this even predates that ACA International decision. So simple answer is we have two big pending dockets before the FCC.
Okay.
The first docket, which was initiated in 2017, relates to reassigned numbers and the FCC's proposal to create a reassigned number database. And the second, which came about after the ACA International decision, relates to interpretation of various terms within the TCPA itself.
Okay, so these are things that the FCC is the one that, I guess, manages the TCPA?
Correct. So Congress enacted the TCPA in 1991, and like most laws, Congress doesn't like to get into the nitty-gritty.
Okay.
So they will direct that authority to one of the various administrative agencies that we have throughout D.C. For telecommunications and telemarketing, the FCC is that predominant organization. So they are in charge of interpreting that statute and resolving the various problems that come up about it.
So Congress essentially says, hey, here's kind of what we think the law should be. They put it in, and then they go, okay, now anything going forward is the FCC's kind of...
We're done with the problem. You
Sounds good to me,
the nitty-gritty. Yep. Mm-hmm.
And then who is this, what do you say, ACA?
ACA International, correct. So the ACA International decision was an appeal from a 2015 FCC order where they had kind of gotten into the nitty-gritty of the TCPA. And long story short, the DC Circuit in the ACA International opinion had struck down various provisions of the TCPA and kind of signaled maybe some change needed to come about, and that's where the FCC has brought us today.
So they essentially kind of put it on the FCC's doorstep and said, get to it when you can?
They did, yep.
Okay.
So immediately after that decision was released, we started to see courts still having to deal with this issue.
Because the FCC hasn't done anything.
Because the FCC hasn't done anything. And primarily these two dockets relate to three kind of big issues.
Okay.
One of them is the interpretation of the term automatic telephone dialing system.
Okay.
One of the biggest terms out there for the TCPA. Revocation of consent.
Like opting out.
Opting out, yep. And then the third one is reassigned numbers and interpreting the term called party within the TCPA.
So is there any responsibility of the FCC to get to these things at a certain time, or...
There is not. No, there is not, and that's why we did see them kind of come out pretty quickly. I think in May they issued a public notice saying, "Hey, industry, we need to re-examine some of these issues. We want some comments." So traditionally, what the FCC will do when they're going to broach a subject and implement some changes is they'll first seek out comment from the industry.
So they get the thing in, like, hey, we want this kind of stuff changed. Then they're like, okay, we're not going to do anything until we get more opinions on what.
Correct.
Okay.
Yep. So they'll reach out. They'll say, hey, this is the issue we have. So for example, for the ATDS definition, they'll say, hey, the DC Circuit struck down our interpretation of this definition. Obviously, we need to change it. And first, we're looking for what you think the definition should be. How have you reacted to it so far? How the courts have been interpreting it? Do you like that? What do you think we should do? What's your basis for that decision? Can you derive that from Congress's intent? So really get down deep into it to come up with an answer.
So for text message marketers, I know obviously the question is what TCPA issues are pending. So now we know the issues. There are two or three. What were they?
There are 2 dockets, but really 3
issues.
Reassigned
Okay.
numbers, revocation of consent, and definition of an ATDS.
And why do legitimate text message marketers, brands that are sending mass text messages, why do they care about this? Like, what changes, or
Sure.
why do they need to stay up?
Sure.
to date?
So we can, I guess, go through each of them
sure.
individually because each are important to,
Okay.
to text message marketers. So the first is the definition of automatic telephone dialing system.
ATDS. Right?
ATDS.
Sometimes. Okay.
So within the TCPA, ATDS is defined as equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. So that is the definition that is within the TCPA itself, the federal law.
Okay.
But that definition isn't very clear.
Yeah.
Congress or the FCC is tasked with interpreting that.
Okay.
And essentially what they had done in 2015 and years earlier was interpreted within that the word capacity and interpreted it extremely broadly, such that, as the DC Circuit recognized, any device could be read into this. Even your cell phone could be deemed an automatic telephone
holds the
dialing system.
power to do it, even though it doesn't do
Correct.
it. It holds the power to do it. So what does that mean for text message marketers? What if it swings one way or the other? How does that impact text message marketers?
So really, the key issue that the courts have been debating, and that now the FCC is going to have to debate, is does that definition only include devices, or platforms that can generate and dial and text numbers randomly or sequentially, just any number, which is our opinion of what it should be, only those devices, or does it also include devices that can store numbers from a curated list and dial out of that list?
Okay. So really just the clarification will make everything easier. These kind of professional plaintiffs, it'll be harder to file lawsuits kind of in the gray areas because it will be resolved.
And it'll help marketers and brands know whether the device they're actually using is an ATDS or is not. Because remember, if it's not an ATDS and you're texting a mobile phone, the TCPA doesn't apply to you. If
So you might not even need to
ATDS.
follow the TCPA if the rules come out that however you're text messaging, whatever app.
For that, yes, for that
use
specific
case.
area, right.
Interesting. Okay, so then there's the second one?
The second one is revocation of consent.
Okay, so opting out.
Opting out. And what we've been seeing here is something that, started to come about a little before ACA International, but then came about there. And this was the DC Circuit saying, we understand that brands, marketers, callers, they need to opt out people who withdraw their consent by a reasonable means.
Okay.
Which again isn't defined. But they also say
nobody defines anything.
Of course, and the word reasonableness is just that one in law generally that's never defined. But what they did say in that opinion, or indicated, was that, there are methods that are unreasonable.
Okay.
And brands shouldn't be required to honor those opt-outs because it's too difficult to maybe come about.
So like if you're mass text messaging and most reasonable people, they would reply stop or end or quit, and that's also CTIA and CARER, required, but that's not the TCPA. So this kind of reasonable thing is, well, in kind of the middle ground, what if I go to the retail store and I tell the teenage worker there, it's part-time, I say, hey, remove me from the SMS list. And they're like, I don't know what SMS list you're talking about. Well, I just reasonably did that. Or what about, just yelling outside the business, when they're closed? Like, I guess that's where the gray area is kind of being
and
exploited.
what the FCC is asking now is they want, commenters to again say, hey, just give us some ideas. What do you think is reasonable? What do you think is not reasonable? Are there maybe standardized opt-out mechanisms that we can, require
like
brands or callers to use? Correct.
Have provided and we've been offering forever.
Sure, and often people, think that the CTIA guidelines are a good barometer for reasonableness. If someone is opting out in a way that the CTI guidelines require, marketers to use, that's probably going to be deemed a reasonable way of opt-out, and a brand needs to honor that. But that's not part of the TCPA.
Okay.
And the question they're starting to ask is, should we maybe cement in this law and in our rules prescribed ways that brands need to provide to consumers?
So ways you
to opt out?
can, so like, by messaging back these specific words.
Correct.
Or maybe messaging back anything, and then we as providers and brands have to, look through those messages.
Or requiring a brand to have like an opt-out website.
Okay, interesting.
Something that's one of the ones they mentioned.
Okay.
So things like that.
So really just making it concrete and clear.
Sure.
Because I think that's brands, they want to follow the rules, but if there's 10 different interpretations of the rules,
Correct.
it's very hard to do. Okay, so these when you go to the FCC and you kind of put something out there, it's essentially just give me more information and make it clearer so I can do a better job.
Yeah.
Okay.
So the FCC's function is to hear out the public.
Okay.
Right? And, obviously this FCC that we have is more conservative, pro-business, which is good for brands and marketers. They want to constrain that liability. But their job is also to hear out consumers and the businesses, and to kind of be that mediator and decide, what do we need, what don't we need, how can we make this clear, how can we help everybody.
Because we don't want to swing it so far that you just can't opt out.
Correct.
There's that middle ground.
We want to protect people's privacy, but we also want to, make sure businesses don't lose their minds just trying to comply with this rule.
Following this stuff. Okay, and then there's one other one.
One other one, and that is reassigned telephone numbers.
Okay.
And this is where kind of the two dockets are intersecting. So first, and we'll talk about this kind of more in depth in another video, is the reassigned telephone number database.
Yep.
The FCC has started to recognize that we need to provide or help provide a method by which marketers can understand when a number has been reassigned, so that they aren't contacting consumers who no longer have that phone number and people who don't want to receive these messages.
And this sometimes happens when, let's say your phone number right now, you opt into hypothetically Chipotle or Macy's, text messaging program, and you love their messages. But then let's say you go off to Europe and you give up your phone number.
Right.
You give back to AT&T. AT&T will give it to another new customer, and then Macy's or Chipotle just continues to send that phone number
because they never get notification that the number has been given to somebody else.
So super annoying from the consumer standpoint. The brand doesn't want to do it, but they don't have the info. So what is being kind of asked of the FCC?
So initially this started in 2017. Okay. And at first it was just a proposal of, should we create some sort of database? Very broad, open-ended question. Should we do this? And throughout the end of 2017, a lot of the industry got engaged in this rulemaking, and they made clear, yes, this is something we want. So what began in March of 2018 was a deeper dive. Okay, we know we want a reassigned number database, but what do we want that to look like? Do we want to make it voluntary, or is it required on the carriers?
So really
to
the specifics.
Yeah, the specifics.
Okay.
And that docket is ongoing. And when a docket is ongoing, that means that as long as certain nitty-gritty rules don't apply, you can go and meet with FCC staff and talk about this issue. It's still an ongoing proceeding. They're still looking for information. Obviously, it'll be time-consuming, but very important for brands and marketers to follow.
Do you think we'll get resolutions for any of these in 2018 or 2019?
2019 might be a better picture. Probably not 2018, which is some of the other proceedings that are on the FCC's plate right now. But it's very clear this is something that the industry wants, and now it's just the task of deciding exactly what that is and implementing it.
Because the FCC also does a lot of other stuff. It's not like their TCPA is their main job. So this is one of their things on their plate.
Correct. And while they're working on that, they also have to deal with the reassigned number issues that are coming out of their TCPA interpretation docket.
Okay.
And
so it's not easy.
No, and they're looking at the definition of called party. So under the TCPA, you are allowed to send text messages to individuals or to the called party to which you have consent. And the way the FCC has traditionally interpreted the term called party is not to mean the consumer, the brand, thought they were texting, but the person who actually has that phone number. So very limited.
Okay, yeah.
And that's how we get the reassigned number issue. So now they're looking at and they're asking, hey, you know, the DC Circuit had struck down that interpretation as unreasonable. And they're now asking, should we make this a broader interpretation? You know, should we have it mean the customer that the brand thought they were reaching?
Yeah,
you know,
the end user almost. Yeah.
end user, correct. So broadening that out. So that's the final reassigned number issue that's pending.
Man, a lot of people think that the TCPA is just the TCPA and it's kind of like the 10 Commandments. It doesn't change and it sits there. That is never the case.
No, more like Commandment 10A, B, C,
yeah,
D.
and it's always changing and updating.
Correct.
That's why we at Tatango always recommend employing a TCPA attorney. I think it's interesting to note you guys only focus on TCPA,
We
right?
do. We're in the weeds every day.
Like this is not a a division of your law firm. Your whole law firm just focus on TCPA, so you guys will know exactly when these things happen and you're staying up to date and then updating your clients. These videos are great, but they give you an overview.
Yeah. Certainly not deep in.
Yeah, exactly. So, and I think they're nice because they educate the public. They let you ask the right questions to your TCPA attorney and just make sure you're talking to a good TCPA attorney. But always employ a TCPA attorney if you're using SMS marketing.
Definitely a good
because the
idea.
risks are just so huge right now.
They are. They are.
Well, you've heard it from John Nelson, TCPA attorney. Employ a TCPA attorney. Again, my name is Derek Johnson from Tatango.com, and we're answering questions from the internet on TCPA, really everything TCPA.